The fatal shooting of Trayvon Martin by George Zimmerman in February in Florida has sparked a national debate. At the legal center of this issue lies Florida's Stand Your Ground law, which states that a person may use force in self-defense where there is a reasonable belief of a threat without an obligation to retreat first. But Florida is not alone. 25 states have similar laws, including Texas. Tonight, a look at the pros and cons of Stand Your Ground. I'm Ernie Manous, and this is Houston 8. Joining us tonight are Ken Williams, professor, South Texas College of Law, Eric Davis, assistant public defender, Harris County, and Geoffrey Korn, presidential research professor of law, South Texas College of Law. Before we start, remember you can share your thoughts throughout the show on Twitter using hashtag Houston8. And welcome to all of you, gentlemen. I guess the place to start is we heard a lot recently in the news before all of this just happened about the Castle Doctrine. How are Castle Doctrines and Stand Your Ground laws different, and how are they similar?
The law of homicidal self-defense, the right to use deadly force to defend yourself, has always recognized that you don't have an obligation to retreat from your home. This was called the Castle Doctrine, and it was only one piece of the self-defense equation, but it was an important piece. If you're threatened in your home, the jury is not going to consider whether you should have run from your home instead of standing your ground. What Stand Your Ground laws have done is they've eliminated the retreat requirement no matter where you are. So if you are threatened with imminent death or grievous bodily harm in Texas or in Florida or in other states, and you use deadly force in self-defense, the jury is not allowed to consider whether retreating, whether running away, was a viable alternative. That's what a Stand Your Ground law does. But it doesn't eliminate the requirement that you make a reasonable judgment that your life was in danger and that you use a proportional amount of force in response.
Okay, Ken, why shouldn't you first consider retreat? If, especially in cases we've heard about, you have called 911 or you can leave the scene and call 911, why shouldn't that be in the equation?
Well, some states believe that once you've been threatened, then to require the person to retreat, you may actually endanger your life by requiring that the person retreat. So once the person has been under a threat, they have a right to basically see it through and to protect themselves to the fullest. That's the argument in favor of those laws.
Okay, Eric, let me throw out for you then, the way I'm looking at this and from what I've read, this is how I see this can work. I can go to the park, I can feel threatened because there's a group of, and I'll use the word hoodlums over there, so I can pull out a gun and shoot them.
Well, not actually.
Why not?
The law still says in it, the language of the law is you can meet force with force. So your equation would have to be if there's a group of hoodlums and they come over to you and start threatening you, maybe pushing you around, and then maybe one grabs a hammer and takes out a hammer and is threatening you with it.
Does the law actually say that? Or does the law just say, I have to perceive that I am in jeopardy?
Now, Florida's
not that I have to be, but I have to perceive it.
Well, actually, Florida's law actually has the words in it, force for force, meaning, in other words, you can stand your ground and meet force with force. And most statutes that cover self-defense usually talk about reasonableness. They have to be reasonable in your apprehension of the force, and you have to use proportionate force. I haven't looked at every state's self-defense statute, but most self-defense statutes actually talk about the proportionate amount of force.
And see, this is, I think, where we all share a concern over the public discourse of this Stand Your Ground. Because the Stand Your Ground language makes it sound like if you're armed and you're somewhere and you think you're threatened, you can just immediately resort to deadly force. Stand your ground is only one piece of the equation. So, yes, the first question the jury has to ask is, did the defendant, the person who used deadly force, subjectively believe that he was under threat? But then the jury has to ask, was that belief objectively reasonable under all the facts and circumstances? And if they say no, then the use of deadly force was invalid, irrespective of whether you had a retreat obligation.
There was recently a case that happened, and of course I can't remember where or the people, so this will be a good example, but it was at a playground, and a gentleman came up to another gentleman and was verbal with him. The first gentleman goes to his house, comes back with a gun and shoots him.
And that actually was in Florida.
Okay.
And it was a veteran of the Iraq War, a Navy service member who had come back, and he was on the playground with his child.
Right.
And the owner of a home came out and was harassing some of the teenagers that were skateboarding. So the father just said, why don't you leave them alone? They're not doing anything wrong. And the individual came out with a gun and came out. And when the veteran of combat saw a pistol, he jumped on the elderly man, and the elderly man shot and killed him immediately in front of his daughter. And the Florida authorities arrested that individual. And I think that that's an example of what we're talking about. You can't just go create a violent affray and then say, well, I have a right to stand my ground. He had no right to bring a gun to that verbal confrontation because he had not been threatened with death or grievous bodily harm at that point. So his use of deadly force was from the inception invalid.
But his argument was, and his defense was, or is currently, is that he feared for his life in that moment and was able to use deadly force.
But I think like similar to the Trayvon Martin case, it sounds like the issue is going to be, was this gentleman the initial aggressor? You can't claim self-defense. I can't pick a fight with you, and then when you respond, I go ahead and kill you. Well, in that situation, I can't claim self-defense because I'm the one who started the whole fight. And that's going to be a major issue in the Trayvon Martin case. Mr. Zimmerman follows Trayvon Martin around, gets out of his car, and confronts Trayvon Martin. So one of the questions the jury's going to have to ask is, well, was Zimmerman the initial aggressor? If so, then he really had no right to use self-defense.
How does he legally have... Well, I cut you off. I'll let you go
No, I was
first.
just going to say, sometimes the statute is a starting point. Oftentimes, here in Texas, for example, even though the statute might not speak directly to an issue, there'll be some instructions that'll be given to a jury that'll elaborate on the statute. For example, verbal provocation alone is not enough to justify the use of deadly force or force to defend oneself. And the court will instruct the jury as to that during a trial. That doesn't appear in the statute, but that's an instruction that will be given to the jury, and that's the law as has been set out by courts. And I think what your initial question went to if there was verbal provocation. Someone actually came in and I got in an argument and I had a gun and I felt threatened by the argument and I shot and I killed this person. Verbal provocation alone is not enough to justify self-defense.
Okay, how, though, can you use the stand-your-ground defense if, in fact, from what we know in the Zimmerman case, without retrying it, he is in his car on his phone with 911, telling them what he is seeing, and they are dispatching someone.
Right.
So he is in no threat for his own life, and the police have been notified.
This is, I think, the point, that stand your ground has confused people. Our view, I think, on those facts, if that's what plays out in court, and we, as
because I would say so much that is, of everything in it, we know what I just said to be actually factually true. Both sides will agree that part happened.
The point is that if he gets out of the car and approaches this young man, and he instigates a combat, right, then as Ken says, the law says his hands are dirty. And if your hands are dirty, you're not allowed to claim self-defense. The way I teach my students, if you're the first aggressor, it's as if your hands have oil on them. And if you try and pick up the self-defense tool, you can't grasp it because you're the one who created the problem. And at its very core, I think it's important to recognize self-defense is a doctrine of necessity. In other words, it was a measure of last resort. You had no other viable option other than to take the law into your own hands to protect yourself. So if you caused the confrontation, then you had an alternate option, which is not cause the confrontation. Or if you are reacting to something that's not an imminent threat, you had another option, which is to wait to see if the verbal provocation escalates to an actual violent threat. And all the retreat law was, historically, was a rule that said, if running away was a feasible alternative, then run. And what Florida...
So why is that a bad idea? Why shouldn't that be... And I understand, with a gun, running away, retreating, you could be shot in the back. You could still be... But outside of that, retreating, why isn't that something that we are not taught that should be the first response?
Well, I think, my view is, what legislatures have done, like Texas, like Florida, is they've looked at it and they said that retreat requirement, that you have to consider running if it's a feasible alternative. And by the way, from the origins of self-defense, if running away wouldn't protect you, you could stand your ground. That's always been part of the law.
Right.
But it was a judgment you had to make. I think what legislatures have done is they've said, unlike the 16 and 1700s in England, most violent threats today, sufficient to trigger the right of self-defense, come from firearms. And therefore, we shouldn't put a citizen in this position of having to wonder, if I'm threatened with a gun, should I run? Now, it's somewhat overbroad because sometimes the violent threat is not from a firearm. But what Texas and Florida have done is they've said, we're just not going to make you wonder whether or not you have to run. If you face a threat of imminent death or grievous bodily harm, you have no obligation to retreat.
Eric, I think I keep leaving you out because you're so far away from me.
It's all right. I'm speaking from the standpoint of defending self-defense cases, defending cases where that's an issue. And I've defended some under both scenarios, under the scenario where there's a duty to retreat and under the scenario where there isn't a duty to retreat. And one of the things I think is very interesting when you have a duty to retreat is that clients say that I never thought about that. Under the stress of the moment, the stress of the situation, I wasn't thinking about retreating. I was thinking about preserving my life. And I think the legislature kind of encompasses that. The burden, you don't want to put a burden on citizens. And just to argue the other side for just a second, you don't want to put a burden on citizens that if they're in a stressful situation, their lives are being threatened, at least they believe their lives are being threatened, that they have to then have the wherewithal to turn around and decide to try to run or try to retreat. The things that go on in that short period of time for some people, in terms of clients that I encounter, is that it's an intense feeling, an intense situation. They're fearing for their lives, and the thought they thought about initially was just to protect themselves. That was it. Simply put, just protect themselves. And in terms of Zimmerman, that's what he's going to have to argue. He's going to have to argue that at the time that occurred with Trayvon Martin, at that moment he was merely thinking about protecting himself. Wasn't thinking about running, wasn't thinking about any of the issues about he got out of his car. Yeah, he got out of his car, shouldn't have got out of his car, but he's going to have to freeze it in time to that moment. To that moment, the moment that he was in a tussle with Trayvon Martin, with Martin, and that he decided to defend himself at that moment. Right. I mean, if we look at the entire picture, he got out of the car, shouldn't have got out of the car.
Had he never gotten out of a car,
it would have never
we
happened.
wouldn't even be having this show today.
Wouldn't have this discussion.
Right.
But when you think about it, his lawyer's going to have to argue when he got out of the car, he didn't commit a crime. Right. He wasn't in violation of law, so we say his hands are dirty, but he wasn't stealing. He wasn't breaking any laws. He disobeyed what someone told him over the phone, which was within his right at that point in time. He was still someplace he had a right to be when he pulled out a weapon and he shot Trayvon Martin. Simply put. He's doing everything that he has a right to do. And if he can make the argument successfully that he was there observing, that he didn't attack Trayvon Martin, that Trayvon Martin came at him and attacked him, then he may have an argument. He may have an argument that he acted in self-defense. I think proportionality may still be an issue for him, though. And by that, he used too much force. In other words, you can't bring a gun to a fist fight.
Right.
But that becomes the key, right? The key becomes what happened immediately preceding his resort to deadly force, because that's where, in other words, if you think about it, these are like obstacles the defendant has to penetrate. And the first obstacle the defendant has to overcome is that it was not his fault that he had to use deadly force. So if he's just walking behind Trayvon and Trayvon turns and attacks him, then he gets past that obstacle. But if he grabbed Trayvon, or not make it not Trayvon, if any person is suspicious and they're following someone in the neighborhood and they grab them or they commit a battery against them and that person turns to defend themselves, then the jury has to say, well, the only reason he had to resort to deadly force was because he started the confrontation. And that's going to be, I think, the decisive question in this case.
Yeah, I would agree. I think that's the big question. What happened when he got out of the car against the instructions of the 911 operator, got out of the car and he confronted Trayvon Martin? Presumably, it was an unfriendly confrontation. He had been following him. What did he say to him when he initially confronted him?
That brings me back to another point, actually, since we're not here to try that case.
Sure.
That's why we're using it to explore it's at the moment that the incident happens that you have to be looking at. And right now, we don't know exactly what happened in that moment. But you mentioned, both of you, all three of you actually, mentioned the 911 call, and where the 911 operator said to him, "We don't need you to be doing that." Are you following him? Yes, I'm following. We don't need you to be doing that. As a citizen, are we supposed to follow? Are they an officer of the law, the person at the other end of that 911 call? Are we obligated to follow what they're telling us? If a police officer said, get back in your car, you have to get back in your car. The verbiage is very clever in what the 911, it's going to lead to a lot of issues, but if the 911 operator were to say to Zimmerman, get back in your car, does he have a responsibility to obey that request?
I would argue he doesn't. I think it would be prudent for him, and I think it's definitely something that goes to the factor about whether or not he was being reasonable.
Right, and I'm not talking about what's a good idea.
Yeah.
Legally, what authority does that 911 operator have? Any?
I think at that point, mostly what 911 operators are doing is collecting information, and they're relaying
Are
it
they
to
an
police
officer
officers.
or not?
Most of them are not police officers. At least not. I'm not sure about Florida, but here in Texas, they aren't police officers.
Okay.
They're usually just dispatchers. They're civil servants. They're employees who work, and they don't function as police officers. It would have been different if a police officer was at the scene to say, "Look, Mrs. Zimmer, you need to stay right here."
And I think a lot of people are confused about that. They're hearing the 911 operator said, "Do this," and I think they're assuming that's a police officer telling you, get back in the car.
I think the issue from a prosecution standpoint is that it goes to his mental state at that It goes to George Zimmerman's mental state. And that may have been a reason why there may have been a grand jury impanel, because they may have been contemplating charging him with first degree at some point, because they may have thought this was an execution, that this guy had made up his mind that he was going to kill that person, and the 911 tape corroborates that, because he's being told, don't do it, we're sending officers, and he still proceeds afterwards. Same thing with Joe Horn.
Well, and I just want to go right there. He's not being told, don't do it. He's being told you don't have to do it, which I think is going to be an interesting legal point.
The exact language was, we don't need you to do that.
Right. It's not saying don't do it.
Don't do it. We don't need you to do that.
But even assuming that you had a state or a municipal ordinance that said you have an obligation to comply with 911 operators, which I agree, I don't think that's a law. Even assuming that's the case, even if it was a cop who said, stay here while I run around the corner and check what's going on, and he disobeyed that, that doesn't automatically mean that he can't claim self-defense if he's subsequently attacked. But I think where it's critical is, as we go back to what we all agree on, which is a big question will always be, who was the first aggressor? The fact that he ignored that admonition may suggest to the jury that he was inclined to violence, that he was already prone to a confrontation.
But even if he did, even if they can support that fact, but at the moment of confrontation, isn't the slate erased and we start fresh at that moment? What was the situation when it happened?
It is, but trying to figure out what happened through all the circumstantial evidence. If I'm on a jury, if I'm a prosecutor, I'm going to argue to them. The fact that he got out of his car after he was advised not to gives you insight into who really did provoke this fight. And that could be important.
Take me then back over to Joe Horn.
I agree with that.
And if I remember that case correctly, he was the one down in Pasadena who shot the criminals at the neighbor's house while they were robbing it. He's told on the 911 call, stay in your house, do not go out there. He leaves his home where he's safe into the neighbor's yard and then confronts once again, our hoodlums. They're everywhere. And shoots at them.
You know, the thing about the Joe Horn case, what if Joe Horn got no bill by a grand jury because he was right? You follow me? What if Joe Horn was wrong? If Joe Horn had been wrong and those weren't hoodlums, let's say that instead of being hoodlums, they were guys that his neighbor had contracted with that he didn't know about, that were going to go by and do some work on the house. And he sees them and it looks like they're breaking in, and he goes over and he shoots and kills them. If he's wrong and these are innocent people that he had shot and killed, he probably would have gotten indicted. The fact that Joe Horn got no bill, I think, had nothing to do with whether or not his shot was really legally justified. It was just that a grand jury didn't think he should be charged with it. A grand jury looked at it and said, hey, look, this is wrong. What's to charge this guy? These guys who were illegal aliens, they were breaking in, they're multiple convicted felons, illegal aliens, and they were breaking in somebody's house, and he came over and he put out the trash, is what a grand jury did in that situation. You follow me? And gave him a pass.
I think that does raise a very important issue about this case, which is we all agree that we don't know what the ultimate outcome will be. We wouldn't know what the ultimate outcome with Joe Horn would be. But I think what the people should expect is that the system works properly, that the process works properly. And for us, what was disappointing initially was the perception that the process had failed, that a prosecutor looked at facts that any, I think, reasonable prosecutor would say justify at least starting the prosecutorial process and said, cut it off at the very beginning. And now we see that being corrected. So with the Joe Horn case, the process ran its course. Sometimes it doesn't result in something that we all agree with, but a grand jury said, for whatever reason, we're not going forward. And that's that.
Okay, well, take me back then, Ken. Take me back to Florida. And we get into the scuffle, whatever happened in that moment. And let's say Trayvon did hit George's head against the ground. If it's not a deadly force, does Zimmerman have the right to shoot him? Does it have to be deadly force?
Yeah, it would have to be deadly force that he's being threatened with in order to shoot someone, to respond with deadly force. One point I wanted to make that's being lost is that Trayvon might have actually had a right to use deadly force. Trayvon has someone he doesn't know following him. According to the 911 call, he started to run, and if Zimmerman confronts him, well, you think about it this way. If you're walking on the street at night, somebody starts following you and chasing you, well, I would argue in that situation you have a right to use self-defense. So even if Trayvon started the encounter, I think Zimmerman legally has a problem because as the initial aggressor, he started a confrontation. If I start a confrontation with you and then you respond with deadly force, then I still don't have a right to kill you.
I guess where I'm trying to find out is what is that line when it is legal for me to use deadly force back against you?
When you are reasonable in believing that your life is being threatened.
And there's where I have my
problem. You don't
problem.
have to be right. You can be reasonable.
It's my perception of the situation.
I can give you, there's a case Professor Horn and I covered, the Bernard Goetz case, which got as much publicity at the time as the Trayvon Martin case. He's sitting on a train, subway in New York. Some guys approach him and say, give me $5. And he pulls out a gun and he starts shooting. He was ultimately acquitted by a jury in New York of the murder charges because the jury obviously accepted the fact that he was reasonable at believing he was in danger. Turns out that a lot of people didn't agree with that verdict, but the jury obviously felt as though he was reasonable in believing he was in danger when he shot two or three of them.
I actually disagree. I think that case is another example of
Joe Horn.
I think
the jury
assuming
says
you're taking
you
out
put
the
out
trash.
the trash. But the rule is very clear. You have to make a reasonable judgment of necessity. That means you have to make a reasonable judgment that your life is in imminent danger of being lost. It can be, it doesn't have to be from a gun or a knife. If your head is being slammed onto concrete, a jury is going to look at that and say, would a reasonable person having their head slammed into the concrete believe that their life was in imminent danger? And then you have an obligation to use only the amount of force that's required to protect yourself. And that's the other point, that the use of deadly force just because you're being attacked is not always reasonable. You have to use proportionate force, and that's another question that the jury has to critique.
Eric?
I'd agree. I mean, I think that's ultimately the issue. It's a jury question. And the problem that we had before was that it was never going to be presented to the jury, that some lawyer was making a decision not to bring in those charges in that kind of case, which was problematic when an officer is seeking an arrest in a case.
Explain a little bit about that, how potentially it could have not gone to a trial. What is that situation?
Well, obviously in the situation was one where a police officer was seeking an arrest, or at least filed an affidavit, was going to make an arrest, and was stopped by a prosecutor, is what I've heard. Now, I haven't been there. I don't know firsthand knowledge.
But a police officer makes the judgment at the moment whether or not this should be pushed as a criminal act or if it's a
If an officer has probable cause to arrest, he can make an arrest. And based on their investigation, they believe they had probable cause. And they
But
presented
in general, they're the first line that decides.
Exactly.
They look at the situation and they say, stand your ground.
That's right.
He can go home.
Here in Texas, for example, it might work where an officer goes and believes he has probable cause. He will call the DA. He'll call the DA and say, hey, this is what I've got. This is the situation. This is how everything's laid out. Can I make an arrest? And the DA will usually tell him over the phone, yes, go ahead and make an arrest. They'll make an arrest. The case won't get presented to the grand jury initially. There may be some investigation in between the arrest and prior to it being presented to the grand jury. In Florida, it works a little bit differently, and that's that the police officer can make an arrest. And once an arrest is made, unless they're seeking first-degree charges, the case doesn't get presented to the grand jury. The prosecutor has something like 42 days or so to do an investigation and has an opportunity to investigate that case. And after they investigate it, if they see that they have enough, they file what's called an information if the person's in jail. If the person isn't in jail, then the time periods are all different. In this situation, George Zimmerman was never arrested. Police officers came to Ms. Corley, came to whoever the state attorney was, and then eventually it got to Ms. Corley's hands. She investigates the case. She makes the determination that, hey, we have enough to file charges here. She files an information, and then an arrest warrant's issued for the person who the information is filed against.
Well, a fascinating case. Is going to be interesting to follow through and see what ends up happening. Gentlemen, I hope you'll all consider coming back and joining us when we know more about what's going on with that and help us understand our laws better. Thank you very much for coming in. Now, each week we invite you to visit our home online at houstonpbs.org/Houston8. There you can read about the guests, learn more about the topic, and even watch past episodes. Next week on Houston 8, Dr. Stephen Kleinberg, co-director of the Kindle Institute, reveals the results from this year's Houston Area Survey and what it means for the future of Houston. That's everything for us tonight, and we will join you back here next week on Houston 8. I'm Ernie Manous. Thank you for watching, and have a great week.